Hello, everyone. Welcome to Court with Krissy. Breaking news. I connected with the Supreme Court, and they can confirm that they have also blocked Mr. English. I hope you like it. Court with Krissy is now in session.
Mr. English, are you able to hear me?
Yeah.
All right, we'll on the record in People versus Michael English, file number 244923 and 244925. The record should reflect that Mr. English is present by video from Department of Corrections. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Michael Horowitz on behalf of defendant.
Thank you. This is set for a final status conference in file number 4925 today. We have a trial currently set to proceed on August 22nd. We also have Mr. Horowitz, who filed a motion to withdraw as counsel. Is that correct?
I attached Mr. English's motion. Mr. English attempted to file a motion pro se with the court. The court, I believe that Your Honor had not reviewed it, but the court did send it to me, forwarded it to me. And in that motion, Mr. English had referred to a breakdown in the attorney-client communications and had asked for either a new attorney or to represent himself. So I wanted to convey his wishes, attach that to a motion that I filed to the court and hopefully captured his sentiment. And yeah, so it sounds, I believe I'm his third attorney. I don't think that.
You're only my second, and I've been calling you for 3-4 months straight. You never answer my call. You don't respond to me. That's why I filed my motion. I haven't heard from you in over 3 months since our last court hearing. And the only time I talked to you was at the court hearing. I haven't heard from you since.
So I'm trying to make the point that you can represent yourself with decorum and that you can follow the court rules. And that would include not doing outbursts and speaking only when you're addressed to. So if you want to make the point that you're capable of representing yourself, I would suggest you exhibit that behavior to the judge today. Okay, thank you. I did explain in the motion, Your Honor, that I did have to block Mr. English's number because of the persistent calling, being disruptive and perhaps abusive. To my mind, there's no actual breakdown in the attorney-client relationship other than I can't have my phone ringing 13 times consecutively while I'm in a trial. Other than that, the request was, I know that Mr. English has had decorum problems in the past, and perhaps minorly today, but I suspect that's somewhat caused by him being on Zoom. So yeah, I think it's his request is to be rid of me and to proceed on his own. I did attach his filing. The court can review that as an exhibit. As to the whatever the orders were with regards to no contact, I had been to the clerk's office months ago to review the file, identify those orders.
1 second. Mr. English is disconnected. So let's just take a quick break. Miss, can you contact Jen? Call the facility. Oh no, that's right. No, he's not in Wexford.
Oh, I'm sorry.
Oh, okay.
Okay, so for the record, what I'd like to do, because I don't know if Mr. English voluntarily disconnected himself, which he has done in the past, or whether that is an actual connection problem. So I'd like to pass this matter. And again, I say that because he has disconnected voluntarily from these hearings in the past. I'm going to have staff contact the facility to see if it was him voluntarily disconnecting or whether they had some kind of, oh, here we go, hold on. All right, Mr. English, are you back? Can you hear me now?
Yeah.
Okay, all right. Go ahead, Mr. Horowitz.
Yeah, I was explaining the orders, Your Honor. I did go to the clerk's office some months ago and sift through the two files, identify the orders, mark them for the clerk, and then the clerk's office copied those orders for me, and I provided those to counsel by mail. I don't know why they're still an issue. I have copies with me today that I was going to give to Mr. English had he not received the ones the court already provided in return in response to his inquiry. But yeah, I don't think I have anything else to say on the matter.
Okay. All right, thank you, Mr. English. Do you want to represent yourself, or how do you want to proceed?
I was like, I can do whatever I had to because he's not been there to help me. He's not, like I said, he blocked my calls for no reason. I'm trying to inquire about my court cases and he wants to not answer my calls and block me.
Okay, are you asking to represent yourself, or what are you asking the court to do?
To either let me represent myself or give me another counsel due to his efficiency of lack of communication.
Okay, other than that circumstance where he blocked your calls, do you have any other issues with the representation?
Yeah, like I said, he's not doing anything for me. He's not trying to help me to go through my case. He's not willing to get my subpoenas done. He's not willing to do anything to help me out.
Okay, so you feel that he's not properly consulting with you, and he hasn't issued subpoenas that you're asking him to issue?
Yes.
Are there any other matters?
Misrepresentation.
Are there any other things that you feel that he should be doing that he's not doing?
Right now that I'm aware of it, I know.
Okay, all right. Can you address, you've already addressed the calling issue, I understand that, Mr. Horowitz, as to, and I think the consulting is probably part of that. As to the subpoenas, what's your view on that?
So, Your Honor, in terms of consulting, I mean, frankly, I can understand why he would just want to talk about his case. Incarcerated defendants generally want to talk about their case, even if there's no changes. There's been no change in the case. It's remained the same. It's remained a relatively straightforward, easy case to go to trial. And frankly, there's been no change that would warrant any sort of discussion that I'm aware of. That said, with the subpoena, the only subpoena as to this trial that Mr. English has asked for is for a subpoena of his significant other or wife. And my understanding is the people will be calling her anyway. I don't need to subpoena her. She's a material witness. It's not somebody I need to subpoena.
Okay, Mr. Ziegler, is that correct?
It is correct. Cheyenne Marvin will be under subpoena on our witness list.
Okay. All right, so Mr. English, the court is going to deny your request to substitute counsel. That's a matter that's within the discretion of the court.
Okay, I will be contacting the Supreme Court because you're in this conduct yourself.
All right, that time Mr. English I saw him with the remote in his hand. He did disconnect himself from the hearing. So in terms of my ruling, again, whether or not to appoint substitute counsel is something that's within the discretion of the court. I guess I should make it clear for the record. Mr. English is no longer present in the virtual courtroom. It's my view, based on my observation here, that he had the remote in his hand and that he voluntarily disconnected himself. Mr. Ziegler, did you see that?
I did as well, Your Honor.
I don't know if you saw it. Mr.
I was not watching. I find it very hard to believe that MDOC puts the remotes in the inmates' hands. It's not helpful. But I don't disagree with Your Honor's characterization. I wasn't watching.
Okay. I think that would also be consistent with Mr. English's behavior when he gets rulings that he doesn't like as well, which clearly he did not like my ruling there. But I do need to make a record of the ruling as well as the record of his voluntarily ceasing his participation in this hearing. So again, it's within the discretion of the court. The court is required to not conduct a full evidentiary hearing, but certainly inquire in as to the defendant's complaints or concerns, as well as the counsel's responses or explanations. I did that here on the record today. Generally, where there's just general unhappiness, where counsel has not been inattentive to their responsibilities, where they've not been just disinterested, or whether the representation has not been inadequate. Those are not reasons to replace appointed counsel. Counsel's failure to file frivolous motions or subpoena irrelevant witnesses are not a basis to appoint new counsel. And even where there's complaints of lack of contact, unless it's prejudicial to the case or somehow is to the extent that the defendant isn't adequately represented, that is also not a basis. So here the court finds, number one, Mr. Horowitz's explanations for the lack of contact to be reasonable. Number one, he was in a different state for a period of time. Reasonable contact, I think, would include not multiple calls, as Mr. Horowitz described on the record today. And I accept counsel's representations, given Mr. English's behavior here in court and what I've witnessed. I think those kind of calls would be consistent kind of with how he operates. So I think the fact that he was blocked from doing that by counsel isn't unreasonable, and doesn't mean that Mr. Horowitz has been inattentive to his case. And again, may not be the contact that Mr. English wants, but I don't think that's the standard. And that would include consulting about the case. In terms of the complaint about the subpoenas, it sounds like the witness that Mr. English would have wanted to be subpoenaed is subpoenaed by the prosecutor and will be a witness that's called at trial. So I don't find that that's a valid reason to substitute counsel. So for those reasons, the court finds within its discretion that it will deny the motion to vacate the appointment of Mr. Horowitz. And we'll proceed to trial in this case. The only thing I could say, Mr. Horowitz, is your client is either going to cooperate with you or he's not. And I'm just going to ask you to be prepared to the best of your ability and to present your case as best you can. I will be prepared, obviously, to address Mr. English's behavior here in court. I'm not sure how that's going to go, but we'll do the best that we can. I know about it ahead of time, so I'll do the best that I can to be prepared to address that. But I don't think we can really do much ahead of time in terms of putting procedures in place. I think it's going to depend on what Mr. English does the day of trial, but this is a case that needs to go forward. It's been adjourned before. So we will proceed with trial on the morning of the 22nd. Mr. Ziegler, I will ask that your office writs Mr. English for his appearance here in court. Mr. Horowitz, I'm just going to ask that you attempt to make arrangements for Mr. English to have street clothes or appropriate clothing. Again, that's largely going to be up to Mr. English as to whether he wants to cooperate with that. And I'll have to address that for the record at the time, depending on how that goes. Mr. Ziegler, if you haven't already, I'll just ask that you submit your proposed jury instructions and verdict form Mr. Horowitz, you don't need to submit full text, but only additional instructions that you would request or any objections that you have to prosecutor's submissions. Mr. Ziegler, can you think of anything else that we need to address today?
No, Your Honor.
Mr. Horowitz?
Not really. I guess I should put on the record, Your Honor. Mr. English did ask me, or did want a motion to be filed about judicial disqualification. I did indicate that I would file that. I looked into it. I decided that it's not meritorious, and I'm not going to file it. Thank you.
Okay, thank you. All right, so if that's all for this case, we will proceed on the morning of the 22nd scheduled. Once that file is resolved one way or the other, then we'll address file number 244923. So at this point, I'm just going to set that file as a status conference at the same time as the trial in the other file.